Landlords, what do you do when your tenant gives you a 30-day notice to vacate, but they leave unauthorized or unknown individuals in the home? Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos here. I actually had this situation come up a couple of times in the past couple of weeks here. The story is this. Tenant either gives a written notice to vacate, like a 30-day notice to vacate, or they come to an agreement with their landlord saying that, hey, I'm going to need to vacate. The parties mutually agree to terminate the tenancy and so forth. And when the landlords come in to do the final inspection, grab the keys, lo and behold, tenant brings up, hey, I got my boyfriend, he doesn't have a place to stay. We broke up. He's your problem now, landlord. Or it might be like a family member that's not going to be moving in with the tenant and so forth. And the landlords are calling me and telling me what to do here. Well, kind of depends on the circumstance. Okay. In the first case where you have a tenant that gave you 30-day notice, in the Code of Civil Procedure under Section 1161, Subdivision 5, if a tenant gives you notice, basically, that they're going to vacate, and they don't basically comply with the notice, a landlord could base an unlawful detainer or an eviction case on the tenant's notice and, allege that the tenant didn't deliver possession of the property as agreed. A lot of times tenants believe, hey, I left, so I complied. Landlord, you figure it out. No. Under the Code of Civil Procedure, a subtenant, that would be another person other than the tenant is occupying the property. So sorry, tenant, that's not going to hold water. In fact, I probably would name you in the eviction complaint as well because you're occupying the property through another third-party person that you invited over into the property. Another way that a landlord might be able to address the problem, and this is the reason why you might want to have a written lease agreement too, is they're unauthorized individuals there and you have an assignment or no subletting provision in your lease agreement, you could issue possibly a 3-day notice to quit and to get rid of that person and to start an eviction that way. And that would be under Code of Civil Procedure 1161 Subdivision 4. That would be an incurable lease violation. Thing is, you got to have a lease agreement and you got to have a provision that has no subletting or assignment in it. So these are really highly factual circumstances here. It might be best to talk with landlords counsel about how to address these things because you might be in a local municipality that regulates evictions. The protections are more stronger than state law. You might have to comply with local notice requirements. You might have to comply with the Tenants Protection Act, and these are highly factual circumstances that can flip on, change of the facts, basically. So talking with landlords counsel might be the best way of going about this and not going about it alone, making that legal decision. Okay. If you have a problem like this, please feel free to reach out to our office. We serve Northern California, northern part of the San Francisco Bay Area. So we're here to help talk with you through that. If you've got any questions, comments, put them in the comments below, and I'll try to answer the questions to the best of my ability. Till next time, folks, I'll talk to you then. Thanks.